Okay, I think I got everything going. So thank you all for joining me. And we'll probably have some other people kind of coming in later. And what I want to do is spend some time recapping this term without focusing on the abortion case, although I may have to mention that in relation to one of the themes I'm going to discuss. So I've got a lot of talking to do. And I know you're going to be all excited. I even have a PowerPoint to keep me on track. So, all right. So here we go. All right. So as I said, we're going to do this wrap up. First things first. Yesterday was the last day of the term, but also the beginning and the end of something significant. So Justice Breyer retired, and Justice Ketanji Brown Jackson was sworn in. So that was a momentous day. And she took 2 oaths. The judicial oath was administered by Justice Breyer, and the constitutional oath was administered by the Chief Justice. And I believe that's her husband holding her Bibles there. And the other thing, just because I can, is my wife won 2 bronze medals at the National Senior Olympics last month. And so I never miss a chance to talk about how proud I am of her. Okay, finally, a lot happened this term, and there are some important cases I won't talk about. We just don't have time. And I picked these out. Not only are they important, but they also show that the court isn't always bitterly divided. And so in these 4 cases, you see that the votes were either 8-1 or 9-0, and they made significant contributions to the law, particularly the first one involving the former president's presidential records. So, you know, there is a side to the Supreme Court story that is often missed, and that is that they are not always at each other's throats, and that sometimes cases get to them that are easy for them to decide where everyone agrees. Now, so mute your mics, please. So in the background, the court accepts less than 1% of the cases that are brought to them. There's no mandatory appellate jurisdiction. And so every case the court gets is an important case. So here are the cases I'm going to talk about, and I want to hit on 3 themes. That's why I picked them out. So mute your mic, please. So the cases overruled significant precedent, established new standards focusing on history and tradition, which have the potential for transforming the law going forward. And by the end of the term, notwithstanding their earlier unanimity, you could see some real animosity among the justices in a way that I don't think has been obvious for many years. Okay, so history and tradition. There are 3 cases that matter in that regard. The Dobbs case, I'll refer to that as the abortion case, the Bruin case, the gun case, and the Kennedy case, the prayer case. And they have these 3 things in common. They both overruled or disregarded previous precedent. They used history and tradition, or established that as the standard going forward. And
Hey, Dean DePippa, I think you can mute people from your computer.
I can, but I can't. There's a lot of people here and I keep looking for them.
Lisa, mute yourself, please.
Good, thank you.
Got it. Thank you. I knew I could. There are just a lot of people to scroll through. And these cases set up the prospect of future turmoil, despite what the court said to the controversy. So real quick reminder about Dobbs. Mississippi passed the law that banned abortion after 15 weeks. At first, that was the only question it asked to consider. Later, it included a request to overturn Roe, and that's what the court considered, and that's what the court eventually did. And you know, many of the parameters of that decision, how the court said they're going to be looking to history and tradition, and it doesn't deal with any other rights. And here's an instance where you can see the animosity of the justices. The dissent says, either the mass of the majority's opinion is hypocrisy or additional constitutional rights are under threat. It's one or the other. That's a pretty unusually direct statement that you find judges making toward one another. Now, the other case involving this refashioning of the standard is Bruin. It's the gun case. New York had a law that allowed people to carry weapons with a permit, but only if they could show what the law called proper cause. And the court had previously only decided two gun cases, two Second Amendment cases, Heller and McDonald. And in Heller, the court said that the Second Amendment right was a personal right related in the right of self-defense. But from 2008 to this case, they hadn't taken any other decisions. And the lower courts had fashioned a way of dealing with these cases because they kept coming to them. And the lower court said that a regulation would be okay if it met what was called intermediate scrutiny. And that means the government had to have an important reason and to show that the regulation substantially advanced that important reason. So it's sort of middle level hurdle. You can't get away with anything, but sometimes the government can win. Most of the circuits had adopted that standard. The court said the New York's proper cause rule was unconstitutional because it prevented law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right. And the court threw out that intermediate standard and said the lower courts got it wrong. When the government regulates guns, they must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. So there's that history and tradition again. And the court said there's two steps. First step is you look at whether the modern compared to the historical regulation imposed comparable burdens on the right of armed self-defense. So cities and states can regulate the carrying of weapons, but only if the burden is comparable to the historical regulation. And then the second step is if that burden is comparably justified. And there what they mean is, are the reasons why, say, this people in 1787 wanted to regulate the carrying of weapons comparable to the reasons people want to regulate those weapons today? That's a pretty narrow window. Okay? Now, the court was quick to say, listen, nothing we say here means that anything goes. Right? Nothing here talks about states regulating who may possess a firearm or the requirements that must be met to buy a gun, think age, and maybe training, nor does it decide anything about the kinds of weapons that people may possess, think AR-15s, nor have we disturbed what we said in those other two cases about restrictions in what are called sensitive places. Okay. So three things seem to be open going forward, all right? And I say open in that they're open questions. One, the state may decide who may and may not possess a firearm and may impose some requirements that must be met in order to buy a gun. Two, state can deal with what the Heller case called unusual weapons. Three, the state can limit the carrying of weapons in certain places. Now, each of those things, however, has to meet this historical test. Each of those things has to show that there were similar regulations historically, primarily around the time of the framing of the Constitution or the adoption of the 14th Amendment in 1868, and that the burdens were comparable and that they're being imposed for the same reasons. So there will be a lot more gun cases, particularly as some states move to tighten their regulations. And lower courts now have to apply this historical burden test. Okay? Now, let's talk a little about history. The historical analysis promises to be more objective, right? So Justice Breyer pointed out that there have always been laws from England coming forward regulating the public carriage of guns. But the majority answered and said, what matters is when the constitutional rights were enshrined, you understand them with the scope they understood to have when the people adopted them in 1789 or 1868. Historical evidence long before or long after doesn't tell us that. That's an important feature, right? So the Second Amendment means what people thought it meant in 1791 or 1868, and nothing more. And that even if, say, post-1868 or pre-1791, as Justice Breyer pointed out, there were lots of regulations of handguns. The court says those don't matter. What matters were the regulations and what people thought when those parts of the Constitution were adopted. That's all that matters. Pretty narrow test. Now, again, it promises, this method advanced by scholars in the court promises to be more objective. The promise is, well, judges aren't going to put their own values into this. They're going to look at history and adopt the objective meaning of history. The problem with that is that it's hard to say that there's a single meaning. So even in the Heller case, for example, right, the majority in dissent put up competing histories. In the Brown case, as you see, the majority in dissent put up competing plausible readings of the historical record. Post Heller, a group of historians have said the court got it all wrong. They got the history wrong in Heller. And so it seems to me that rather than promising some objective foundation, history is just another way of introducing the judge's interpretive biases. Because you can pick and choose the history you want to think is important in order to reach your desired outcome. And again, and you see that in these competing versions of history. And finally, the prayer case, and that was decided last week. And the court held that the free exercise and free speech clauses protect an individual engaging in personal religious observance from government reprisal. The Constitution doesn't mandate or permit the government to suppress this personal religious observance. Okay. Now, there's a lot going on in this case. There are a lot of moving parts because it involves not just free exercise claim, not just a free speech claim, but also the background of the Establishment Clause. So we can start out again with an example of some of the animosity that seems to be creeping in. So this is the majority's description of the facts. And I chose a picture that I think correlates with the majority's description. You can see it seems pretty innocuous, private, personal. This is the dissent's description of the practice with a picture of what was happening, of one of the prayers. And I believe this was. Okay, so I think for Rhonda, you're not muted. Can you please mute yourself? Anyways, you can see the red arrow points to the coach. The group of players from both teams are surrounding him. He's holding up a helmet and using a kind of motivational speech that he described as a prayer. So how you characterize these facts really matters. And again, it exposes this sort of perspective that ends up being brought here that really is the individual perspective. If it's the first one, all right, then that seems pretty normal. If it's the second one, that seems more contentious. Now, I think this is a hard case. I think it's very, very close to all of the different lines. And because there's so much going on, I just want to spend a couple minutes talking about all this background. Right? So you have two religion clauses. And the text of the Constitution says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Those clauses have been applied to the states. The interpretive question is always, what's the relationship between the clauses? That's important in this Kennedy case. And not only the relationship, but how do you properly interpret them? So here's what the court did. It said, we've got all this stuff going on. And in the end, what it boiled down to was, did the school districts fear that if they permitted the coach to continue to pray the way he had been, did their fear that that would be an Establishment Clause violation? So David, please mute yourself. Justify restrictions on free exercise, the coach's free exercise, and his free speech, both as a government employee and as a private citizen. The court answered that question by saying no, because the school district and the lower courts didn't understand the law of the Establishment Clause. They didn't understand the relationship between the two clauses, and especially they didn't understand the law of the Establishment Clause. On the relationship, they said, look, the Establishment Clause isn't a veto on the Free Exercise Clause. It doesn't mean that the Free Exercise Clause can only work if it's okay on the establishment side. And the court said both of those are designed to amplify religious liberty, not to limit them. And then on the proper interpretation of the Establishment Clause, the court said lower courts used this lemon test and its offshoots, especially the endorsement test. But the Lemon Test was, as the court described, ambitious, abstract, and ahistorical, and the court had long ago abandoned it. And therefore, the proper standard, and here we have history and tradition again, is that limitations that raise Establishment Clause questions must be interpreted by reference to historical practices and understandings. Now, why is that important? Because both under the free exercise and the free speech clause, the government can regulate free exercise of religion or free speech only if it can show it's got a compelling reason to do so, a really important reason. And the school district kept saying, well, look, our important reason is we don't want to violate the Establishment Clause. And the court said, yeah, but you got the Establishment Clause wrong. Come up with a better idea. If not, you lose. So what was this Lemon Test? It had 3 parts. It said a law would be okay if it had a secular purpose, if its primary effect was neither to inhibit nor encourage religion, and if it avoided excessive entanglement between the government and religion. And the court developed this test in the 70s. But truthfully, over the years, nobody liked it. And the court frequently didn't even follow it. And they often refined it in precise applications. And this is where this endorsement test came from, which said a government violates the Establishment Clause if a reasonable observer looking at the situation, knowing everything about it, would conclude that the government was endorsing religion. And the court throws that out. Now, Justice Scalia perhaps raised the most colorful description of the Lemon Test when he called it a ghoul in a late night horror movie, repeatedly sits up in its grave and shuffles abroad. It stalks our Establishment Clause jurisprudence, frightening little children and school attorneys. And that latter is what the court focused on, because they essentially said to the school and its attorneys, you were scared by this Lemon Test, which doesn't apply anymore. And so you didn't need to be scared by the Lemon Test. You need to think about history. Now, just a brief excursion into what I think this historical test is going to look like in future cases. And it derives from this case a few years ago, where the court upheld this 40-foot cross that was erected in 1925, honoring the county's soldiers from World War I. And in that case, 5 of the justices had something to say about the Lemon Test. Right? Justice Alito says, it's got to die. Justice Thomas said, it never really was a test anyway. Justice Kavanaugh says, it's already died. Justice Ginsburg said, hey, it's kind of useful. And Justice Breyer said, a little too rigid. We should just use it as a guideline. So you can see Lemon was hanging by, I don't know, what would a lemon hang by? But it wasn't in particularly good shape coming into this. So what I think we're going to see going forward in this history and tradition test that the court now requires for Establishment Clause comes from Justice Kavanaugh's opinion in that cross case. And I think you're going to see that the court will apply these standards, right? That the government practice isn't coercive. And if it's rooted in history and tradition, it's going to be okay. So now consider taking this coach's prayer into the classroom, right? It seems pretty clear that the government can't mandate prayer in a public school. I mean, that is coercive. That is the very definition of coercion. But prayer in schools has a long history and tradition. And so it seems to me that the next case, or at least one of them is there, would be a teacher who does what this coach did, but in the classroom, privately before the day starts, engages in prayer. Doesn't require the students to follow, doesn't say you have to do anything, just prays. Is that coercive? Prayer is rooted in history and tradition. Similarly, what if a school says, we're now going to have prayer at the beginning of each day. If you don't want to participate, students, you don't have to. That has a long history prior to 1963 of being okay. And so the new test, I think, opens up those things, which is why I say these history and tradition standards have the potential to transform lots of law going forward. Then I think these other things are other parts of the Establishment Clause application in different contexts, right? The government can't deny benefits to religious groups just because it's afraid that it might violate the Establishment Clause if it allows comparable secular groups to have the same thing. And the government can accommodate religion from a generally applicable law. So I think that's what it's going to look like going forward. I'm pretty confident of the first two. That third one is already the test in the free exercise clause, and the court has long allowed legislative accommodations. Now, what that does, as I said, is it opens up lots of things to potential challenges. So what do I think those cases say? Well, I think this court has shown it has no problem overruling cases or disrupting settled practices. It clearly shows that this historical analysis is the preferred mode, and it's focused again on the time the provisions were adopted, but not thereafter, unless there's a consistent regulation of an asserted right. So you see that in Dobbs, right? The court says, what we know is that there has been a consistent regulation of abortion prior to Roe versus Wade. That's some idea, that's some indication that abortion was not a fundamental right. And compare that to the Broom case, where the court said, well, there were some regulations of firearms, but they weren't anything like the one we're talking about here. And then you see that the justices don't particularly seem to be getting along anymore, and they were sniping beyond normal. Another indication of that goes back to the dissent in Dobbs and a response from the majority, where the dissent was bringing up what they saw were the inconsistencies between the historical approach in Broom and the historical approach in Dobbs. And that accounts in part for the dissent's charge of hypocrisy, where the majority responded by saying, we don't really see the point of any of this. We don't even know why you're bringing it up in a judicial opinion. So it doesn't seem that they're getting along very well. So I'm going to return to the Kennedy case before we move on to other things. I put up chose those pictures of prayer for a reason, and that is that the coach's prayer was seen as normal within the community he lived. What about these other situations? Are they going to receive the same treatment? Logically, they should, if they meet the criteria of private personal expression, even if it is in the workplace. Again, we'll have to see, and we'll have to see if any of these are pursued in any particular way. Now, there's lots more in the Kennedy case. We really don't have time. There's a question of what constitutes coercion. What does it mean to be a public employee and have your speech restricted, lots of bits and pieces that have to be played out. But there's a lot of weeds in that piece. So I want to stop for a second and just ask if anybody has any questions. You know, PowerPoint's managed to do that. I think they do a good job of putting people to sleep. Now, a couple of the religion cases, this one in particular. The state of Maine could not deny funds to parents who wanted to send their children to religious schools when it gives funds to parents who want to send their children to private secular schools. And Maine had a really unique setup. Maine, because it's largely rural, there are parts of the state that don't have any public schools. And the state concluded over the years it would be cost prohibitive to have public schools there. So they said to parents in those areas, we'll send you the equivalent money of what we would have spent on your child. And you can spend that to send your kids to private schools. But you can't send them to religious schools. You can't use that money to send them to religious schools. You do that, you got to pay yourself. And the court said, no surprise here, because they've been moving this way, you can't single out religion when you're giving out a neutral benefit, that is money to parents for their kids' education. You can't single them out. And so if you're going to fund private secular schools, you also have to fund parents who want to send their kids to private religious schools. Now, this is of a piece with last year's case involving the Philadelphia and the Diocese of Philadelphia and adoption, and the COVID cases, at least the latter ones. And it shows that religion gets what scholars have called the most favored nation status. That is, if the government does anything in terms of giving out benefits, it cannot leave religion out unless it has a really good reason to do so. And there aren't going to be any really good reasons to leave religion out. Now, there's a big if there, right? If the government funds things. So if Maine is going to fund private schools, got to give money to parents who want to send their kids to religious schools. Maine could set up public schools and say, okay, your choice is send your kid to a public school or pay for a private school on your own. But there's another thing that Maine is doing that probably will make a difference. Maine could condition the receipt of the money they give to parents on using that money in a certain way. And what the Maine legislature did in the spring was adopted a law that said, parents, you can use this money at private schools, religious, secular, doesn't matter, but only if those schools don't teach discriminatory concepts. And they listed them all. And these are the plaintiffs in the case, and they actually chose not to accept the money because the school they wanted to send their child to wouldn't have qualified because of its teachings. And so in some ways, this case is much smaller than it appeared at first because it involves the state conditioning the grant of funds. As long as it doesn't condition it on religion and on something else, should be okay. Okay, let me go through a couple of more of these miscellaneous ones. This is an important case for litigators. Here it said that a violation of the Miranda rules does not provide a basis for a 1983 claim. That's a claim that allows people to sue government officials. And the particular action is called a Bivens action that allowed people to sue government officials in their personal capacity and get money. And the court held that because the Miranda warnings are not really part of the constitutional guarantee against self-incrimination, they're just protective of it, they're not part of it, they don't qualify for this Bivens claim. So it narrows the universe. And the court has done some other things to really narrow Bivens only to the sorts of cases that gave rise to it, involving violations of the Fourth Amendment's guarantee against unreasonable searches and seizures. I want to end with these administrative cases and spend some time with the West Virginia one. So the court decided two cases yesterday. They upheld the government's rescission of what has been called stay in Mexico or remain in Mexico policy. And that in administrative law terms, the memo the administration issued on October 29th was the final agency action. And they upheld that by a vote of 5-4. On the other hand, in West Virginia versus the EPA, the court said that Congress didn't grant the EPA power to regulate emissions based on what's called a generation shifting approach. Now, what does that mean? What the Clean Power Act did, and this was from an Obama era law, instead of regulating specific emissions from specific facilities, they said to facilities, listen, you can do this in a number of different ways. And one of those is you can engage in a cap and trade plan. Now, last fall, the court decided two other administrative cases. Again, there was a split decision. And in the decision where the court said that the Biden administration couldn't mandate vaccines for certain large employers, they used the same legal standard they did in West Virginia versus EPA. So, real quick background, right? The goal of this plan was to reduce the use of coal for electrical generation by 10% by 2030. And the operators of these plants had three ways to do it. They could just improve their plant and burn their coal cleaner. That's a traditional way of regulating things. They could build or invest in a new natural gas plant, wind farm, or solar installation. They could still keep burning coal. They just had to invest in a new facility or purchase emission credits as part of a cap and trade regime. And the court said, listen, the first one's okay. But when you do something that is so different and could cause so much change, you, being the EPA, has to have clear authorization to do so. And that's called the major questions doctrine. The court says ordinarily we're going to let agencies do things, but when they assert some broad authority that's out of character and it has very large economic and political assertion impacts, the agency must show clear congressional authorization, and they didn't have that. Now, it's really a product of a 50-year effort to rein in the administrative state. If you think about administrative agencies, they're not mentioned in the Constitution, but it'd be hard in the modern world to run the government without them. And so Congress will pass laws with the general principles and then say to these agencies, do something to make these regulations. Ordinarily, we defer to agency experience, that's a chevron, except when you have these major questions. So that's a potentially huge shift because Congress could authorize this, but given the current state of politics, not likely. And so if every regulation like this one has to have this kind of justification, things may not go very well. And then one last case. The court granted cert, which means they'll hear the case this fall in what's called the independent state legislature doctrine. And I put up the issue from the petition. what's going on is this is North Carolina. North Carolina redrew its congressional maps. Its state court struck them down under the state constitution. And the appeal is that state courts can't do that, that the Constitution only allows the legislature to make changes or to draw and make changes to these legislative maps, not even the state courts. And that's a hugely important decision, particularly going forward in 2024. Okay, well, I talked a lot. Sorry about that. Anybody have any questions? It's going to be hard for me to see the chat, so just go ahead and raise your hand. Okay, David.
Hi, Professor DePippa, question about going back to Dobbs. There's a lot of talk about codification of Roe v. Wade at the federal level. Given that the right to abortion is no longer a federally protected right, what would give Congress the authority to do that? And before you say Commerce Clause, don't say Commerce Clause.
Well, Commerce Clause, but also the spending clause. The Congress could condition the receipt of federal funds, particularly for healthcare, on a state not banning abortion, and that's consistent with the whole line of cases, but particularly that COVID case. The Commerce Clause clearly applies because they've already used it to outlaw what at the time were called partial birth abortions. And the court didn't directly hold, but they said, yeah, we're not going to worry about it because it sounds like a Commerce Clause regulation. And they've also used the Commerce Clause in what's called the Freedom of Access to Clinic Entrances Act, which protected clinics from certain disruptive behavior. So if I'm choosing the Commerce Clause, then the spending clause. What's clearly out of play would be Section 5 of the 14th Amendment that allows Congress to pass legislation to enact the 14th Amendment. Abortion isn't, according to the court, in the 14th Amendment, so they couldn't do that. Okay?
Okay.
By the way, I hope she's still, I want to give a shout out to Donna Sensabaugh. Yes, Donna and I go way back to when I worked in legal services in Lexington, Virginia, way back when. So, hi, Donna. Okay, other questions? All right, Alicia.
So I'm looking back in my brain, and it's been a little bit since I took sports law, but one thing we talked about with prayer in schools was just the schools taking on the view, like saying, oh, if we allow prayer, it's basically a representation of the school's views. So how are they going to get around that, especially at like grade school level?
Well, in the Kennedy case, the court said just because the school official prays doesn't mean it's the school's view. Okay. And so if they focused on some of the facts from the majority's perspective that they said separated this out. So they said he was doing it at a time when he wasn't required to be working. And because it was sort of that in-between time after the game and before he went to the locker room, when other people could do private things. He wasn't inviting people at that time. He wasn't leading the prayer in any official capacity. He was doing it by himself. So you have to look at those facts. And it seems to me that, again, if I were thinking about it, the closer you get to the classroom, the more unlike it is what this coach did on the field. And then it's much harder to see it as not representing the school's view. I think the age of the kids makes a difference. The big difference between a first grader's understanding of the world and a senior in high school's understanding. And so I think in context, you'd have to ask, well, maybe elementary school, it's more obvious or more dangerous. I should say that the kids would see this as the school's view and not so much the the private. But what that says is it's all very fact specific in the context in which it happens, and if you can find some historical analog. But just praying as a public employee, as a school teacher, by itself doesn't convert it into the school's viewpoint. Okay. Rachel.
And flavor is the last thing you have to worry about.
I might have already missed this, but how will looking to historical regulations and how people really understood the Second Amendment, how will that standard really be met when the weapons that we are regulating in 2022 are nowhere near the weapons they were regulating in the late 1700s?
Well, there's two things going on. One, notice the court said you have to look at the comparable burden and the comparable justification. Okay, so it seems to me the hunt now is, was there some weapon that was perceived to be so dangerous that people in 1787 or 1868 thought they had to prohibit its possession? I don't know the answer to that, but that's the historical question. Second thing is, in Heller, the court said that the Second Amendment still would prohibit the carrying of unusual weapons. And they're defined as weapons that are not in wide use for self-defense. And so I think that's another one of those factual disputes where is an AR-15, for example, in wide use for self-defense in the same way that a handgun is. I think many people have argued AR-15s are in broad distribution. They may not be the sorts of things that are broadly carried for personal self-defense. So those would be the two ways I think, again, that's what I would say probably courts are going to have to look at. What this means, though, is everybody who litigates these cases has to become a historian, and every judge who decides them has to become a historian. And probably every law professor in the future has to become a historian because so much of the law is now history. Okay. AJ Wentz.
Yeah, Dana Pippa, thank you for doing this. I appreciate it. On the West Virginia versus EPA case, how do you foresee this affecting other administrative agencies? Or do you think we're about to see a wave of lawsuits challenging administrative authority? What do you foresee the effect of this happening?
Yes, I think the answer is yes. I foresee a wave of lawsuits challenging administrative agency actions because the major question doctrine is so squishy, right? I mean, before this major questions doctrine took off, the rule was courts are going to defer to the expertise of the agencies because they're the experts, we're not. And so if there's any basis for what the agency did, we're going to be okay with it. What the major questions doctrine does, though, is it includes this very subjective, I think, interpretive predicate, right? Which is, well, is this beyond the scope of what agencies have usually done? And does it have a really big impact? Okay. And so that means agencies should start using all of their powers so that the court can't say, hey, you haven't used this for a long time. It's probably not good anymore. And two, need to end up being very focused as much as they can on the regulation as opposed to broad system-wide or region-wide impacts. But all that is to say, this is a whole new ballgame. And the other thing that's going on is the court could easily overrule Chevron, which means they would end up substituting their judgment for the wisdom of the agency. So the answer is yes. This is like a full employment for administrative lawyers, the Administrative Law Lawyers Act, because there's going to be a lot of action out there. I thought I saw earlier that Kwame had his hand up. Do you still have a question?
No, sir, you answered it. Thank you.
Okay, thanks. Elizabeth. unmute yourself.
That might be helpful.
Yeah.
Going back to Dobbs and the argument that precedent or stare decisis now seems to be argued on a clear and egregious standard. So do you foresee a lot of briefs just trying to argue, well, it's only been 50 years, and so it's wrong for this reason?
Well, I think Dobbs opens up the possibility. Now, what Dobbs did, the egregiously wrong thing applied to the initial decision in Roe, and that goes back to that historical analysis. And so I think a lot of cases are opened up to that kind of questioning. So any case that involves a due process right, and I suspect, I would say, perhaps even an equal protection claim, is going to be looked at from this standpoint, no matter how long the precedent's out there. Is there some historical basis for it? And then overruling it is going to require the court to walk through those steps it mentioned in Dobbs, which are similar to the ones from Casey. And that is this standard workable? Have the facts changed? Has the law changed? Have people relied on this to their detriment? And none of those, I think, again, none of those are objective criteria. And there's a lot of room for argument into that, because Casey answered all of them as saying, well, that means we shouldn't overrule Roe, right? 20 some years later, Dobbs says, Casey got it wrong, we should. So again, there's no objective feature, just better, good and better arguments on each side. Causley? Did you
Hi,
have your hand up?
Professor.
Yeah.
I did it. I'd taken it down, but that asked my question nonetheless. Going back to what you said about every law professor and others becoming historians, doesn't that just open up the door for like what we have, the battle of the experts? Because everybody's history is going to be different at some point in time.
Sure. And I think there's a couple other things that concern me about this historical approach. One of them is it really takes the law out of the hands of ordinary people. And by that, I mean, ordinary people can't understand the Constitution now because you need a historian to tell you what it means. So you elect somebody to a legislature and they have to, again, be a historian or find a historian to tell them whether or not they could do what they want to do. And for more than 50 years, really going back to the New Deal, the court adopted a standard that said, we're generally going to let legislatures do things because after all, people elected them, except when they infringe on groups that may not be represented well in the legislature, or when they infringe on voting, which prevents people from having their interests heard in the legislature. And this history and tradition thing breaks that, because it basically the Supreme Court's saying, we'll tell you what this means. We're not going to tell you in advance, but we'll tell you what it means if we decide the history matters. Oh, for maybe another personal thing, I also see one of my high school classmates in. So Dan Buffuno, good to see you. I'll see you at our reunion later this month, I hope. Okie dokie. Back to David.
Trying to be provocative. Why do you believe? Yeah. Why do you believe that Justice Clarence Thomas, in his concurring opinion in Dobbs, mentioned Lawrence, Griswold, etc., Obergefell, but did not mention Loving?
Sure.
When Obergefell was equal protection as well as due process, and so was Loving. So he mentioned Obergefell, but he didn't mention Loving.
Yeah. Here's what I would say on that. And this is, I think, this is, I think, the kindest explanation. And there are more suspicious ones, but the kindest is, if you read Loving, it was an equal protection case that only incidentally, really in about a page, said, oh yeah, there's also a fundamental right to marry. But it was largely equal protection, and the equal protection violation was so obvious that you often wonder why the court even mentioned the right to marry. Because it was obvious that the way the Virginia legislature set it up, it was to preserve the purity of the white race. They even said that. Bergefell, the court said, this is primarily a fundamental rights case, even though it's hard to untangle equal protection from fundamental right here, because in treating somebody one way, you're not only denying their rights, but you're denying them equal access to it. But if you read it carefully, they spend much more time elaborating this as a right, a fundamental right, than they do on the equal protection part. And so it seems to me that Thomas's explanation is, look, Loving was about equal protection, Obergefell was not. And I only mentioned the ones that had fundamental rights things. If people want to defend same-sex marriage statutes in the future using equal protection, we'll be happy to hear it. I think that would be his answer. Ferranda?
Thank you so much for doing this. I'm deeply concerned, of course. But if the history of this country is racist and sexist and homophobic, what recourse do historically excluded communities have now that laws are being reinterpreted using that racist, sexist, homophobic history?
Yeah, I think that's a great point. Others have made that point that I've read. I have the same concern, and here's why. If the document only means what people thought it meant at the time it was adopted, then it means racist, homophobic, and misogynistic things. It's hard to escape that. And I think there's a comparison there to Dred Scott, where Dred Scott said the same thing. We're only going to interpret the Constitution the way people thought it meant in 1787, and that means that enslaved people and their descendants can never be citizens. Well, I think it's really problematic when the court decides that it's going to freeze the meaning of these general terms at a time when not everyone had input, and in fact, the general terms were used to deny people freedom. Now, what do you do about that? There's lots of possibilities. Expand the size of the court, limit its jurisdiction, elect different people, appoint different judges. I mean, there's lots of possibilities there. None of those are immediate. The other thing is, this isn't an accident. It's a over 50-year-long development where people built this intellectual architecture about originalism. So there has to be a similar intellectual architecture in and out of law schools, which push back at that notion. I mean, that's the best answer I can give. Adam? I should say Judge.
Well, thank you so much for having this. I really appreciate the invitation. Turning my attention to Dobbs, I'm wondering what your thoughts are on its practical application, because it feels like almost federalist in nature, because when you throw the question of abortion back to the states, it almost promotes that people of like-minded nature move to different states. And I've read in several articles that ultimately will, to some degree, be the result. But we had a war about that. So just the 14th Amendment was almost like a second founding, and
right.
And I just wonder if I'm almost scared by the question of whether or not the practical application of this was fully considered, because I'm afraid of the consequences for our nation. And I'll take.
Yeah. Well, I share your concern that decisions like that, in essence, say, move, if you don't like where you live, move to a state that does things the way you want. Of course, a lot of people can't do that, but other people might, you know? So I do think you might find that sort of in and out migration happening. And the danger is that creates these sort of, it undermines the notion of one country and creates multiple sovereignties, especially to the extent that the court has also protected state sovereignty. And my concern is, I don't think that's the way the Constitution is supposed to work. Those of you who had me in class know that I think McCulloch versus Maryland is the most important case ever. And here's why, among other reasons. It says you have to interpret a constitution to make it work. That is, so it has to actually do what it's supposed to do, that is, govern a large, diverse country. And you have to interpret the Constitution in a way that unifies the country. That it's a single country with multiple states. And it seems to me that a decision like Dobbs and some of the others undermine that notion, that we're not really a single country, especially because I think people have gotten used to, through the Warren Court and the era of Roe, that rights would be respected nationwide. States would be different in their economic policy, things like that, but at least the basic rights would be the same throughout the United States. And I don't think that's true anymore. And I think Chief Justice Marshall in McCulloch warned us about that when he said, constitutions have to work. They can't spell out everything in precise detail. They're going to be written in general terms, and they have to be interpreted not just to work, but to work to deal with the exigencies of the moment that the framers could not possibly have anticipated. And you can say that about gun regulation, you can say that about abortion, you can say that about same-sex marriage. Doing that allows the country to breathe and include broader and broader participants in what Justice Ginsburg used to call we the people. So, I mean, I agree with you. I worry about the divisive effects that decisions like that will have. Okay. All right. Well, listen, thank you for listening to me talk for an hour. I'm out of practice, so my voice is getting rough. Well, I still have hands up. Emily Therese Loker.
I'm just applauding you, Dean DePippa. Thank you.
I thought that was a hand. Thank you. Well, thank you to everybody. All right. I will be posting this, as I said, on YouTube. So if anybody wants to re-listen, you're welcome to. Thanks. See you later.
Thank you so much. Have a great weekend.
Thank you.
You're welcome.